Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with prominent attorney Ms. Sheela Murthy to discuss the latest updates on immigration, followed by frequently asked questions related to H-1B and GC. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We will start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please reach out to the attorneys for a private consultation. You all know very well Ms. Murthy is the founder, CEO, and president of Murthy Law Firm, and she's a Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website. Hi, Ms. Murthy, welcome to the show.
Hi, good afternoon to you, Ranjit, and good morning or good evening, wherever from the world you're calling. We're happy and excited to be here and to help you and explain any latest developments in the law and to answer your questions. And I know that we're all excited to always help you on a weekly basis.
Yeah, before starting the show, Ms. Murthy, could you please give a brief about you and then we can jump into the questions?
Yes, thank you so much, Ranjit. So as many of you know, Murthy.com was started about 28 years ago. It was meant as a pure service to help educate and empower the immigrant population, especially back in those days, pre-internet. There was almost no information available in the world, almost nothing available to give you some insight. If you had any doubts, you had to consult with a lawyer and pay $200, $300, $400, $500 to spend half an hour or an hour. And I just felt it was so tough. Myself, having been a student and having suffered financially, like all of us coming from other countries as immigrants, I didn't want anybody else to go through that kind of a problem. So our goal from the beginning has been to educate and to empower immigrants so that they can learn and get knowledge. And because knowledge is power, you will have power if you have the knowledge and information to plan your life and that of your family members, because it's an extremely long, stressful, slow process with respect to US immigration, particularly for those born in countries like India or China.
Thanks, Ms. Murthy. Thanks for your great information. Okay, let's start with the latest updates. The only latest update I believe we have is, the NIE has been extended as a multiple entry and 12 months. Could you please just briefly tell us about it and then we can take it from there?
Sure. So for those who may not be very familiar, the national interest exemptions or NIEs that were being approved because of the presidential proclamations preventing entry for those coming from certain countries, including India. If you got an NIE approval from the US consulate, it was only valid for a one-time entry within 30 days of the date of issuance. What the consulates just changed last week, and the Department of State has issued an official policy about a week ago, was that it is now valid for up to 12 months. So you don't have to, each time you travel abroad in a 12-month, you don't have to go back and get another approval and wait 6 months or 4 months for it. And it's also available for multiple entry. So you don't have to worry about, oh my God, I made one trip. Now I have another family emergency or work emergency. How can I, get stuck abroad? No problem. We are seeing them approved. Again, remember, the national interest exemptions are primarily based on humanitarian exceptions, helping with COVID-19, prevention, those kinds of factors that are taken into account and how it can help America. If you say how it helps you, the government says, thank you, but I'm not interested in helping you. We have to show you, or your employer has to try and make an argument how bringing that person, giving the H-1 visa for that employee or H-4, etc., will help the United States either battle COVID or help on humanitarian reasons for some very specific reason, etc. So it is very much more targeted, and most of the consulates, particularly in India, have already been very slowly opening up. And so they have not been very helpful, though they have been issuing through the Dropbox method a lot of the people who have made the argument that they should be given a national interest exemption based on H1 or H4 work or showing COVID, doctors or people working in food service industry, even somebody who started a restaurant, I think, was able to come in. There are exceptions, but it's not a blanket.
We have taken this question last time, but then a lot of people were asking. So there are a lot of news going around, especially a lot of attorneys are suggesting to send medicals without RFE. So I don't know how this works, but there are multiple issues at times, and sometimes there are no issues. But what's your take on that? What do you think? Is it a good idea to send the medicals without RFE?
Yeah, I'm generally not in favor of sending any piece of evidence or documents or information to the USCIS unless there is some communication that they will actually find and merge the file together. Because what we have seen over the last 27, 30 years, I was practicing before I started my law firm also, 30 plus years, is if you send something to USCIS, it will go away into this black hole. And I don't know how many weeks or months it'll take to merge it. And in the end, if they don't find it or it's not merged, then you'll again have to go and get another new medical from this medical doctor, from the physician recommended by the USCIS. So in general, I don't like sending anything, what we call unsolicited mail. Unsolicited mail takes weeks, months, and sometimes never gets joined with the file. Even if you put a file number, you put a notice, I think it takes so long that, even to issue a receipt notice when you're sending a big filing fee check, the USCIS takes such a long time that I'm not a huge fan of it. I know some lawyers do it. And yes, sometimes it does get into the file. I'm not saying, miracles can't happen, but I would not trust that would happen. And anyway, by law, once they issue the RFE, because they may ask for an updated Supplement J or an employer statement, whatever else that they need, I would send everything together at one time so that you can be assured of the 485 approval on a more efficient and expedited basis.
A lot of people have this issue, especially when they are trying to enter the country at CBP, because of having passport being expired, sooner than actual H1B. They get I-94 only until a certain period, not full period of the H1B. So what do people should do? What should people do in this case? How do they, let's say after the renewal, what's the option they have other than leaving the country? Exit and entry is the option. But then other than that, are there any options to extend the I-94 after the passport is renewed?
So after the passport is renewed, you can, because the I-94 has been truncated or reduced in time to a much shorter period, which by the way is reciprocity. It's based on the US doing that to Indian nationals and India doing it to US nationals. So it's a reciprocity kind of issue, like a lot of the visa fees. So besides traveling abroad and coming back, if you're traveling again and getting a fresh I-94 with the new passport and the H1 approval, you would have to file an H1 extension. Just like let it take its own sweet time. It doesn't matter. Just say extension is based solely on travel abroad when the passport expired, because if you hadn't traveled abroad, then you wouldn't have had this problem at all in the first place. And then the next thing that some people do, they do the extension at the same time, because if there's only like 6 months remaining, then it may make sense to file for next 3 full years for the employer based on the I-140 approval, to ask for a 3 full years, so you're not wasting attorney time and process legal fees just to get a short 6-month extension. So you can do the extension within the US. Now, sometimes we have argued at the Murthy Law Firm, because there are old AILA liaison minutes from, I think, from over to almost 20 years ago, from 2001, I believe, which says that as long as the person has any I-94 card that is valid when they travel abroad and return, because it's truncated, shorter I-94 card, you can actually file the H1 extension by showing that you had the H1B validity, because the employer and employee are both protected by law in using that initial H1B approval that was valid for the full 3 years rather than the shorter duration, even though there is something called the last action rule, which says that the latest action of the USCIS/Department of Homeland Security determines the status of that person. So the safest approach, of course, is to file the extension on time, but some people don't even realize it's a problem till later. Then we have made the argument by filing the extension before the original I-94 expired, and filed for the full 3 years by attaching a copy of the original approval notice saying that the person was legally permitted because USCIS had approved for that person to work for the full 3 years. And the only reason that this problem occurred was because of the person having traveled internationally and triggered the shorter duration of the I-94 based on the earlier passport expiration date. Now, this is extremely important for every person to check the I-94 card when you come in. People don't bother. They think, oh, I have an H-1 approved. Be careful, because we have seen this problem happen over and over and over again. It's not worth it.
Thanks, Ms. Murthy. We have Sam again on the call. Hi, Sam. Welcome to the show. Please go ahead and ask your question.
Sure, thanks. Hello, Ms. Murthy. Thanks for giving me this opportunity to ask a couple of questions. I just have two questions. The very first question is, H-1B holder legally allowed to work more than 2 jobs in IT at the same time between 9 to 5 Eastern time?
No, not unless the person has 2 separate H-1B approvals, Sam. So the person needs one H-1 approval with employer A and a second for what's called concurrent / simultaneous employment with employer B. Otherwise, an H-1 employee isn't simply allowed to start working with other employers by having just one H-1 approval for one employer, right?
Mm-hmm. Yep. Okay. So do we need to file different H-1B with the different employer when there is an opportunity to work?
Yes. If you want to work for a second employer concurrently, Sam, then the new employer has to file either for part-time or full-time employment. Now, the USCIS may ask, can you really do 2 full-time jobs for 40 hours each and have a normal life? You can ask for 2 full-time jobs, but generally it's 2 part-time jobs or 1 full-time, 1 part-time, because even that's a lot of work, and you won't have much time left for anything else in your life. So, but each employer is absolutely by law required to file for a new H-1B petition and obtain, you can start even just by filing the petition, you can start employment because of the AC-21 portability provisions for H-1B workers. And if it gets approved, then you can continue. If it gets denied, then you would stop on that date. But just upon filing the new concurrent H-1, remember, it can't be for subsequent employment. It has to be for concurrent or simultaneous employment, Sam. Hope that was helpful.
Okay. We have another caller, Ashwin from Virginia. Hi, Ashwin. Welcome to the show. Please go ahead and ask your question.
Hi, this is Ashwin, Sheela. I have 2 questions. The first one is actually I downgraded in EB2 to EB3 in October. So I went for the premium process a couple of times. It was, they denied the premium process. So the first question is, how many times can we request for the premium process? The second question is, suppose if I leave the country right now, I didn't get any EA card or AP as of now. So if I leave the country, what will happen my current 485 is pending?
Yeah, good questions. So with respect, Ashwin, to your first question, there's no limit by law on how many times a person can apply for the premium under the premium processing program. But my thought always is, what is the reason that they're denying it? If they're denying it because they don't have the original perm labor certification in your case, then obviously we need to make sure that you provide them the original, if you can get it from the other file, or link it and tell them where it is available in their own database in the file so that they can then approve this EB3 downgrade case premium. I've seen some cases getting approved, and I've seen based on only referencing the original labor certification, and I've seen some cases getting denied. So as long as you can address their concerns of the USCIS, Ashwin, you shouldn't have a problem. Hopefully, if you address it or preemptively approach it, the next time you request a premium processing, they will be able to approve it for you because you have either given them the information of the new perm or whatever information that is preventing them from approving the premium processing program, EB3 downgrade case for you.
They are saying original perm is not available.
Yeah. So you have to say the original perm is available and it is here with the USCIS in this file number with your case. So that's how you reply the perm. You don't say, yes, you're right. Because if you say, yes, you're right, then they eat you alive and they say, okay, great, then we're not going to approve it. You have to say the original perm is available and with the USCIS, please see EAC number or WAC number or whatever number that is available to confirm that the original file, the original perm is within the jurisdiction and purview and accessible directly by the USCIS, Ashwin. Did your lawyer do that the first time or the second time?
Yeah, they did it 3 times. Even it came back. It was denied. They are saying 30 days we waited. 3 months onwards we are trying that one, but we could not make it.
Yeah, I've been hearing some people getting it, which I was surprised initially that they were accepting it because they love the extra money. So each time they're doing it, they're returning back your full premium processing fee of $2,500 each time?
Only one time. They are returning the money back.
Okay, good. At least they're not keeping the money and refusing. That would be even worse, right? And remind me your second part of your question.
Yeah, that is if I leave the country in any emergency case. So what will happen?
The 485. Yeah, okay. Yeah, so if you travel abroad, so look, the USCIS takes the position, Ashwin, that any travel abroad requires the advance parole for you to re-enter, otherwise the 485 is deemed abandoned by law. There is, however, well before the regulations or well before any, the USCIS policy under the law itself, AC 21, was that there is no problem for a person to be able to travel and return back safely into the United States based on re-entering on H-1B or H-4 status, and the 485 can continue for a person because of the doctrine of dual intent as recognized under the Immigration Act of 1990 or IMAC 1990. However, we have seen some cases where USCIS has actually said, no, all that is old stuff, but according to our present policy, you are not allowed to do that. So out of an abundance of caution, I would avoid travel because unless you're prepared for the USCIS to say that your 485 has been deemed abandoned upon departure from the United States because you did not have the advance parole or the combo EAD and AP card combination to be able to travel and re-enter. Some people have said, look, I don't care if I lose it, I'll file it again because this is a family emergency, I have to go. And sometimes we have seen no problems with those cases where they've been approved. And yet we've heard when we've done consultations and I've spoken to people where they've had some problems in the USCIS claiming that their 485 was deemed abandoned by law and they will get a denial based on abandonment because their advance parole was not approved for them to re-enter. And even this year in July, when we had the June-July of this year, last month, when we had the American Immigration Lawyers Association annual conference, several senior leaders from USCIS made it very clear that they have the right by law to deny the 485 if a person travels abroad, even if they have availability or H-1B visa stamping to come back. Now, remember, H-1 visa stamp, even if you have it, that doesn't mean you can just travel and come back unless we can, again, meet one of the national interest exemption criteria available to you under the presidential proclamations that Biden did because of COVID-19 spread in India, Ashwin. I hope that was helpful. I know that there was a long answer and that was two completely different sort of unrelated questions. And again, your lawyer hopefully has explained all this to you already.
Ms. Murthy, going back to the question one of the viewers asked about concurrent filing. So you were saying that if it involves 2 employers, then concurrent filing is must. That's what you made it clear. But how about doing 2 different jobs with the same employer? Let's say in consulting business or IT staffing business, you can have multiple projects being handled. So how does it work? Do they have to file another H-1B in that case?
If it's 2 projects for the same employer, as long as the LCA, the labor condition application mentioned and the H-1 petition mentioned both work locations, both projects, so that it's already been addressed. Because remember, each time if you're in two different projects in two different states, then you need the separate LCAs to be filed or an amendment. But if all that has been taken care of and it's completely covered, or the second job is also in the exact same MSA, then presumably if it's the same employer, same job, the problem again is also the number of hours. If the first job was 40 hours and the next job is 20 hours, if it's with the same employer, depending on the nature of the job, sometimes there is overtime pay required for certain, what they call non-professional jobs. And sometimes actually they don't. If it was based on an hourly rate, they could pay you the hourly rate. But if it's over 40 hours, sometimes there is a requirement for time and a half pay. So there are many more complications under both US Department of Labor regulations, both federal and state laws. If it's the same employer, there's definitely some red flags that both the H-1 employer and the employee need to be watchful that you're not transgressing or breaking the law. Because if there is a Department of Labor audit on the wage and they say, oh, you worked 60 hours for this person, 40 in one job, 20, did you pay time and a half? Did you do A, B, and C? And then both employer and employee will be considered to be in violation of the law. So be very careful what you do.
So I believe the overtime pay is also specific to some states, I believe, if I'm not wrong.
It's not some states, it's federal law if you work more than 40, but there are exceptions if there's an administrative professional kind of a job. And most software engineers whose jobs require at least a bachelor's degree, like an H-1B specialty occupation, are exempt from the overtime pay, which means actually whether you work 40 hours or 60 hours or 80 hours, you just are supposed to get one flat salary for that time, unless your perm or your labor certification of the LCA mentioned an hourly rate instead of an annual rate, then you have to be paid that extra hourly rate. Otherwise, many jobs, I mean, for example, as a lawyer or as a doctor, whether you work 40 hours in a week or 60 hours in a week, your salary is flat, right? Because that's how it is. So it's not state law, it's federal law regarding overtime pay. And there are, of course, state law components to it, but many professional jobs are exempt. So by working this extra job, if your goal is to make more money, it's okay if the employer gives it to you. But sometimes if your job is considered a professional position, then technically the employer is off the hook and may not have to provide any extra salary, especially if the LCA was not done based on an hourly rate, but was based on a salary for working full time.
Got it. I think that's pretty clear. Okay. Other concern a lot of people are having is, does travel on advanced parole qualify for the NIE? Because AP is considered, is it immigrant or non-immigrant intent? I mean, it's kind of, I believe, gray area, but what's your take on that? Like traveling on advanced parole, because the ban is only on non-immigrant visas, but AP, what is it? What is the AP? I mean, technically it's immigrant intent, because you already...
It's not immigrant intent, actually. AP is just advanced parole. So you're entering the country as a parolee in parole status. You're not being admitted into the United States. You're being paroled by CBP into the United States. So you're allowed to, I mean, you could potentially come in. We've not seen a person who is entering on a parole having an issue trying to enter the United States or re-enter the United States.
So do you think it's safe to get an NIE and travel, or, that's what a lot of people have, like, can you travel without an NIE? Because AP is kind of, a green card is in process, which is an immigrant intent. So that's what a lot of people, I mean, I know there are a lot of gray areas.
Yeah, I mean, honestly, we've never seen a problem with a person traveling and re-entering the United States on the advanced parole. I don't know if tomorrow suddenly some CBP office or airport will suddenly decide, like, oh, there's some unanswered questions on this, because presidential proclamations, there's not a whole lot of law. This is unusual that we've had these kind of presidential proclamations, because we've had a COVID kind of a major pandemic after 102 years. And US immigration law is not 102 years old, as you know from the series when I started discussing immigration law. Most of them barely started, a little over 100 years ago, but they never had any exceptions or exemptions for pandemic and parole and all of those issues. So they've been allowing people to come in. It's a parole entry. It's not an admission. The presidential proclamation denies entry for non-immigrants seeking admission into the United States. Here, you're not seeking admission. You're just seeking to be paroled into the United States on an advanced parole, and you're not seeking admission. And a parole document simply means that they're not examining any details about your background or documents or paperwork or status. They're just paroling you in to continue your 485 processing.
Got it, Ms. Murthy. Thanks. So about this H1B, H4, H4 EAD, filing together. Now that USCIS has taken off biometrics, did you come across, the approvals faster, like in premium, when it used to be in the past, when H1B, H4, and EAD used to be approved together when it's done in premium? Have you come across anything?
Yes, we saw, I think, the first case last week in our office, within the past week because when the biometrics are no longer required, they potentially can approve the H4 and the H4 change of status and the H4 EAD, and it was in a premium processing case. And instead of harassing like the Trump during the prior administration of the Trump, where they harassed and separated the case purposefully to come up with any excuse to delay approving the case after collecting thousands of dollars in filing fees and legal fees and processing fees from employers and employees. Now what we're seeing is that they're actually approving the H1B and the H4 change of status and the H4 EAD in record time. We saw our first case, I think it was last week. So we were quite excited. We're hoping it's a new trend. We don't know if that's an exception or a new trend. Time will tell.
Thanks, Ms. Murthy. Another question is, few people were not successful in doing that. And other thing to add is H4 EAD, L2, and other premium processing the rule is likely in the final stages. That's what we are hearing. So do you think it's going to be implemented soon, and that's one of the reasons why they don't want to approve H4 and H4 EAD to make more money?
So that they can do other H4s separately and process them separately and make more money on premium processing?
Yes, a lot of people are not getting approvals. That's what I'm hearing in a lot of blogs and groups.
Yeah.
And the final rule is still in, I think it's about in the final stages, and we don't know yet when it's going to come. Again,
they're coming up with every excuse to delay, take more money, squeeze more. If any one of us in private business were doing things like that, or in private companies, they might say fraud, misrepresentation, throw you in jail, etc. And yet we see sometimes that the federal government has not been very ethical and above board in treating employers and employees who are contributing to the economy, creating jobs, working hard, paying taxes, doing everything correctly, in treating them with the dignity and respect, because it takes more time and money and effort and energy to separate an H1 and H4 when the only reason for the H4 is because of the dependent status of the H1B. And if you're touching that file one time, the same officer can do all of the three approvals within a few minutes of each other, rather than wasting thousands of dollars in time by separating it, and again, wasting time trying to approve it later on. So I don't know, it smells of blood. I hope it's not that way, but I wouldn't be surprised, because getting $2,500 extra in premium processing is a temptation, because the USCIS is claiming that they're losing money in processing, which again is very difficult to imagine, because they're siphoning out a lot of the money for enforcement, rather than leaving it and focusing on taking care and providing services to the population, employers, employees, and families, as they are required by law to do. That's why the USCIS was created in the first place. The U.S. Citizenship and Immigration Services was created to provide services, and that's why they were separated back in 2003 after September 11th incidents, when they created the U.S. Department of Homeland Security. They created the separate organization of ICE, Immigration and Customs Enforcement, and CBP, Customs and Border Protection, and SEVP, Student and Exchange Visitor Program, so that enforcement of certain aspects would be put with a different agency. But now everybody's trying to get more and more and more money for doing less and less work. It's very sad that's how we have come to. And I really hope that we come back to providing service, taking care of clients, and doing what's right for America in the long haul, which is good for our economy, good for employers, good for employees, good for families, and ultimately will benefit all of us if they're more efficient and honest and transparent in their dealings, just like the way they expect us as private businesses to be in that way.
Thanks, Ms. Murthy. We are towards the end of the show. Again, thanks everyone for the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch this special immigration show with Ms. Murthy. Again, it's every Tuesday at 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Bye, Ms. Murthy.
Thank you very much. Bye-bye.